Hello, everyone. We're going to give people a few more minutes to trickle in. All right, everyone, good afternoon. Thank you for joining us for our Enacted Cannabis Legislation webinar. My name is John Hudak. I'm the Director of the Office of Cannabis Policy. I'll be joined today by my colleague Gabby Barabee-Pierce, who's OCP's Policy Director. I want to provide a little context for today's event. OCP traditionally provides a legislative roundup memorandum after each legislative session to make sure that industry participants and stakeholders are aware of any legislative changes to the medical and adult use cannabis programs. The memo for the first regular and special sessions of the 131st Legislature was shared earlier this week. We're going to provide a link to that memo in the chat function now for anyone who might have missed it. This year, we're also hosting this webinar to go over the legislative changes in more detail and to make ourselves available for any questions you might have about the implementation of these changes or about the upcoming rulemaking process. Please be reminded that both the memo and this webinar are provided by OCP as a courtesy. This information should not be construed as legal advice and should not be viewed as a substitute for consulting with a qualified business consultant or attorney about the application of these changes and requirements, particularly to your business. I want to talk a little bit, or Gabby and I will talk a little bit in this webinar today about a variety of topics: implementation timelines, legislation affecting both the medical and adult use programs. Obviously, the legislation this session applied to both programs. There were changes made to both, and we'll go through each of those separately. And then finally, we're going to talk about the rulemaking process that will come as a result of the legislation and talk a little bit about how you can participate. Before we jump into the legislation, we wanted to provide a brief overview of the various implementation timelines and the different effective dates for different types of bills. It can be a little bit complicated, and so we wanted to lay that groundwork to start. Emergency legislation is effective upon the governor's signature or 10 days post-enactment if the governor chooses to sign, declines to sign or to veto. Non-emergency legislation is effective 90 days after adjournment, sine die. So the general effective date for the first regular session of the 131st Legislature is June 29th of this year. The general effective date for bills passed and enacted in the first special session of the 131st will be effective October 25th of this year. It's important to keep in mind that the legislative branch makes the laws while the executive branch executes and administers those laws, and that's the role that OCP plays here. So the administration of those laws often requires rulemaking, which OCP will be engaging in for both the medical and adult use programs and rules. And so we'll talk a little bit more about that later on. Right now, I'm going to turn it over to Gabby to go over the legislative changes. Gabby?
Thanks so much, John, and thank you all for joining us this afternoon. First, we're going to start with Public Law 2023, Chapter 6, which was more commonly known as LD 83, an emergency law that was passed early in this past legislative session to clarify the interaction between the laws in Maine governing tobacco and the laws governing cannabis. It creates a definition of cannabis paraphernalia for both the Cannabis Legalization Act and the Maine Medical Use of Cannabis Act, and it differentiates cannabis products or cannabis paraphernalia from tobacco products under the laws governing tobacco. Excuse me. And shortly after that law was signed by the governor on March 15th, the Department of Health and Human Services issued guidance to our program participants regarding whether or not they needed to continue to obtain a tobacco retail sales license. And so I believe that we linked to that in our legislative roundup that we did earlier this year. But folks who have questions about the interaction between the tobacco and the cannabis laws should certainly reach out to the Department of Health and Human Services with those questions. Next slide. Great. No, any questions? Sorry. Next, we'll turn to the medical use of cannabis program legislation. There were a couple of bills that were enacted this year. First was a repeal of the sunset on the requirement that the rules drafted by our office for the medical program be affirmatively approved by the legislature before they can be finally adopted by our office. That originally had a sunset date of November 1st of 2025, and that was repealed. And then LD 832, sorry, was an act to sustain the medical use of cannabis program, and that made a number of changes to the medical cannabis program requirements, including eliminating the requirement that registry identification card holders produce not only their registry identification card, but a secondary photo ID in order to prove proof of authorized conduct. Effective later this year, we will be including photographs on all registry identification cards. We've been doing that, I think, for about a year on assistant cards and dispensary officer and director cards, and we will be extending that now to the caregiver registry identification card application and renewal process. So keep an eye out for more guidance on that particular requirement. Additionally, there were a number of changes to the existing medical cannabis statute regarding the Office of Cannabis Policy's enforcement authority and the tools available to OCP to help program participants come into compliance. I'll get into the details of that, but one of the issues that was discussed at length was what the department should be doing when we identify sales to non-patients. And so there was an update to the statute to require the department to notify any affected registrant, a caregiver, or a dispensary if we determined that there was a sale to a non-patient. Next, there were some changes to the rules around forfeiture and destructions of medical cannabis plants and cannabis products for medical use to allow for the forfeiture to the department, and for the department, as opposed to law enforcement, to order destruction of those items. I think one of the things that probably got the most attention this past session was the development of a two-tiered fining structure in the medical cannabis program. And so the law now allows for the department to assess fines for misconduct designated either as a minor violation of the program, major violation of the program, or a major violation affecting public safety. And in allowing for those fines, the statute also sets up two tiers of fines. One specifically for registered caregivers who operate a caregiver retail store, as well as dispensaries, manufacturing facilities, testing facilities, and individuals who extract using inherently hazardous substances. And they also created a second tier of fines for caregivers who do not operate a caregiver retail store, and any person who has a registry identification card who is not a caregiver who operates a retail store. Let's see, sorry, I am having trouble seeing the bottom of the PowerPoint presentation. I apologize if you are as well. But the next thing that was authorized by that same bill, LD 832, was permission for the department to accept donations for registration fees on behalf of individuals. Next slide. Seeing no questions, great. Turning now to the Adult Use Cannabis Program. There were a number of bills that touched on various aspects of the Adult Use Program, and we'll take them each in turn. First, starting with LD 555, which is now Chapter 220 of the public laws for this year. That law will increase the number of adult use cannabis plants an individual can home grow from 3 to 6. Want to be clear that OCP does not have any oversight over home grow, but this is a adult use cannabis bill that was enacted this year. Next was LD 1063, Public Law 444. And we're really excited about this one. This is one that brings parity between the taxation, the tax deductions available to adult use cannabis businesses and medical cannabis businesses by extending what are commonly known as 280E deductions to adult use cannabis businesses. Medical cannabis program participants have been able to take these deductions for a number of years. And we were thrilled to see this bill get across the finish line. And we had I think it was last week, we had a signing ceremony with the governor a week or two ago, because this was, we know this means a lot to the adult use program participants. Next slide, please. Okay, so next up is LD 202, Public Law 2023, Chapter 408, which updates and clarifies the requirements for off-premise sales by cannabis store licensees. And from our view, this really provided us with the clarity and statute necessary for us to engage in rulemaking around this issue. It defines some terms that were previously undefined to help bring clarity to that issue. It also provided some additional clarity around the application requirements. It removed the prohibition on the sale of smokable cannabis and cannabis products at these events. It established criteria for suspension and revocation of those specified event permits. As I said before, it provides us with some additional criteria for consideration at the time of application, and amended the requirements regarding issuance of guidance for those off-premise sales. Any questions around that? Okay, great. LD 1880, this is a long one, so buckle up. This bill, which is now chaptered under 396, does a number of things as well with the adult use cannabis program, including permitting tier 1, tier 2 nursery cultivation facilities, as well as products manufacturing facilities to conduct delivery of cannabis and cannabis products, although there are some additional restrictions on what a nursery cultivation facility can sell by delivery. So it allows those entities to make sales direct to consumers. It also permits the delivery of cannabis and cannabis products to hotels and other private businesses. So it expands the places where cannabis stores and other folks who are doing delivery can deliver. And it created a requirement that any hotels or other private businesses that are permitting delivery to their location will affirm that permission in writing, and then that that authorization will be retained by the licensee who is making the deliveries. It also permits the return of cannabis and cannabis products from one licensee to another, and provides some guidance or some provisions regarding the testing of that returned product. Next slide. Like I said, this is a long one. We're going to continue on with 1880. It also requires our office to give through rulemaking some specific limitations on the kinds of signs and advertising and marketing materials that would be appealing to individuals under the age of 21. It also affirmatively permits the use of vehicle wraps by licensees and increase the per package limit for the potency of edible cannabis products from 100 milligrams per package to 200 milligrams per package, and also allows individuals to possess or purchase 10 grams of cannabis concentrate at any time. That's up from 5 grams. Yes, and the serving size limits continue to be 10 milligrams per serving. And there were no changes made to the allowable variance. So that remains, I'll get to that second question in a minute. That remains the per serving limit is 10 milligrams per serving. The package will be going up to 200 milligrams per package, and the allowable variance will be 10%, but not less than 0.6 milligrams or 5 milligrams variance within that 10%. And now I have to pause for just a second to take a quick peek at this. So with respect to the 5 gram to 10 gram concentrate limit, that will be going into effect October 25th of this year. We will absolutely be putting out additional guidance on the implementation timelines for a lot of these things, and we are going to get into a discussion of rulemaking here in a minute. But just to echo what John said at the top of this discussion, a lot of these changes will require rulemaking to the extent possible, where the law is clear enough already and there is not additional information required to maintain compliance. We are going to do our best to make sure those go into effect October 25th. But there are some things that will require additional rulemaking before they can become effective. Give me just a second, please. Oh, we got more questions coming in. So the question regarding, does this pertain to delivering only of 100 milligram edibles, or is this how much a person can possess? So the per package limit is what can be manufactured into a package. And then the concentrate limit is how much an individual can purchase or possess at one time. I think some of these other questions might be answered as we go along, so I'm gonna continue on. All right, as I mentioned, excuse me, much of this is going to require, much of both the adult use and medical program changes are going to require rulemaking in order to implement these changes. And the bulk of OCP's rulemaking authority for both the medical and the adult use programs is designated as major substantive as opposed to routine technical. Major substantive rules go through a process that is governed by the Maine Administrative Procedures Act. That is in Title V, Chapter 375. And because those are designated as major substantive, we run our rules through the rulemaking process, which includes public notice, a public hearing, an opportunity for public comment, and then revision of the proposed rule in response to those public comments. After OCP has completed all those revisions, we would do what's called provisionally adopt those rules. And then we would submit those rules to the legislature for additional consideration, which will include the holding of a hearing and a work session where the public can be involved. And then the legislature will determine whether to allow those rules to go into effect. After, if the legislature allows those rules to go into effect, unless the instrument they use to allow that is an emergency instrument, those rules would go, or that law or resolve would go into effect 90 days after adjournment of the legislature next year. And then our office has to adopt those rules within 60 days of that resolve or law becoming effective. And then 30 days from the date we finally adopt those rules would become effective. So we are looking at a fairly protracted timeline for the actual implementation of some of these provisions. And so we just want to make sure we're setting folks' expectations. We, as you can see, we are in the process of finalizing the draft adult use rules for consideration, and we should have those posted online next week. And then we are planning on having a public hearing in Augusta at OCP's office on September 6th. And then we will have a public comment period, as we always do, where we can accept written public comments online and also via email or mail. And I cannot stress enough how critically important it is for the public to engage in the rulemaking process. We know that the rules get better every time we get feedback on these rules. So please take some time to review the rules. I do want to preview for everybody that we have taken the gigantic adult use rule and we have broken it down into smaller rules. So you'll see that when we publish the rules next week, that instead of having one big rule that covers the entirety of the adult use program, we're now going to have 4 smaller rules that are more subject matter specific. So keep an eye peeled for that. And a couple of things that I want to highlight, and I think I've probably said this to a lot of you one-on-one, but I want to make sure I tell everybody. We understand that changes to the laws and the rules can be concerning for business owners, and it's really important and helpful for our office to be able to hear from program participants about how these rules are going to affect your day-to-day operations, what sort of costs are going to be associated with those things, and not only a ballpark estimate, but if you have actual estimates or actual costs that you can provide to us so that we can keep that in mind as we're forming the small business impact statement, that would be really, really helpful. So please, please, please participate, and yeah, we'll go from there. I think we're gonna get to the question that just popped up in just a minute, so I'm gonna continue on unless there's anything else we had. You want to go to the next slide? Oh, okay. Well, sorry about that. Hudak, did you have anything you wanted to add?
A few things, but Gabby, do you want to, I'm not sure if you mentioned the forthcoming timeline on medical rules.
Oh, sorry. Yeah, no, I did not. We are in the process of working to develop rules for the medical cannabis program as well, to implement specifically the provisions of LD 832 around compliance and enforcement. And so those rules should be forthcoming in the next few weeks, early fall at the latest. We are really writing pretty furiously. And one of the things that I have shared with some folks is that we are taking into consideration everything that was discussed before the legislature this year with respect to this rulemaking. So all of you who showed up and participated at the legislature this session have already informed some of that rulemaking. So we hope that you'll see that reflected as well. But stay tuned and keep an eye on your email inboxes for additional information and more solid timelines associated with the medical cannabis program rules.
Excellent. Thanks, Gabby. I do want to jump back to a couple of questions that Barry Chaffin, I'm sorry if I'm mispronouncing your last name. Barry, as Gabby had noted, the 200 milligram edibles, the sales of those will begin on October 25th. We will be sure to communicate with the labs to make sure that they are aware of those legislative changes and making sure that they both have a link to this presentation and to make sure that nothing on the labs end will hold up licensees, both obviously manufacturers and then also retail stores as well. As Gabby had mentioned in some of her closing remarks, public participation is absolutely critical for the rulemaking process. This is a really important and often overlooked part of the democratic process. And frankly, if we don't receive information from all of you, we're not going to know how these draft rules may impact positively or negatively your businesses and your day-to-day operations. And so we really encourage you to participate in the public hearing. We recognize that the public hearing is on one day and life happens, both business and personal, and you might not be able, to make that hearing, you might not be able to make it to Augusta, for whatever reasons might restrict your ability to participate in the public hearing. That comment period is open for a week and a half. And so a week and a half after the hearing, sorry, my light went out. So got a lamp here. We really encourage you to participate in written comments as well. And that is not weighted any more or less than participation in the public hearing. And it's critical, as I said, that we hear from you. We need to hear whether the draft rules are overly burdensome, whether they're duplicative, whether they're seen as wasteful, whether they're costly, et cetera. And those are all opportunities to hear from you on that. It's also important too, it's obviously a forum for you guys to register complaints about the draft rules, but it's also important for us to hear positive aspects. So we know that things are effective, that things are items that your businesses are looking forward to, or aspects that can actually help as well. Hold on, a question just popped up with the off-premise sales bill. You mentioned that smokables would now be allowed for sale. So consumption of cannabis in public remains forbidden, even if those products are purchased at an off-premise site. And so thank you for that question. It's really important. I think there can be some confusion around that. And I do know that there was a robust, I won't even say debate, there was robust statements from the Veterans and Legal Affairs Committee during the debate of that bill about how the legislative intent was to ensure that public consumption at these events or outside of these events would not be part of that law that passed. And so it's really important for those rules to be recognized. And certainly for business owners, I think there is a sort of an implied obligation for you to communicate that with customers as well, because the last thing you want is to have a pop-up, let's say, at an event and consumers leave and immediately begin smoking cannabis, and there be a lot of registered complaints about that. And then it will ultimately look bad for the industry. And so there is a communication aspect there that I think is really important in order to preserve off-premise sales in the future and not to really muddy that issue for the legislature or for the general public in future sessions. Information on rulemaking will be made available on the OCP website and will be sent to all program participants as well as stakeholders who are registered on our mailing list. As Gabby had mentioned, there will be a comment form for each chapter for the AU rules. We'll be accepting comments through September 17th. And as I noted, you can also participate in the AU public hearing for rules on September 6th. The timeline on medical rules is forthcoming. We expect that to be announced by the office in the coming weeks. And similarly, there will be a public hearing for the medical rules, and there will also be the open comment period for the medical rules as well. And so we really encourage you and hope that you'll participate as well. That concludes our presentation today. Thank you all for joining. We'll answer any outstanding questions now.
Can I preview one other thing real quick?
Please, Gabby, yeah.
I apologize for not mentioning this earlier, but I do want to, just like we previewed, you're going to be getting 4 rules about the Adult Use Cannabis Program. I do want folks to understand with respect to the changes to the Medical Cannabis Program rule, we are going to be pulling what is currently Section 10 out of the existing Medical Cannabis Program rule and doing a standalone, well, not a standalone, but a chapter specifically related to compliance and enforcement. And that will work in concert with the existing Medical Cannabis Program rule. But as you've probably heard us say time and time again, we continue to really want to see the rest of the Medical Cannabis Program statute to be updated to reflect the current operations in the Medical Cannabis Program before we're going to feel comfortable really kind of doing a top to bottom rewrite of that existing Medical Cannabis Program rule. I'm also happy to answer the question about which specific provisions will need rulemaking. However, I'm going to flip it on its head. So I can tell you what provisions of the newly enacted bills will not require rulemaking and will go into effective October 25th of this year. So as we had indicated in our publication, the increase in home grow from 3 to 6, again, that's not something that our office administers, but that will become effective October 25th. We will continue to accept donations for registration fees in the medical program, and we will begin to have the requirement for new and renewing registered caregivers that they include a photograph effective October 25th of this year. Although I have heard that our system will be available to put photos on cards before then. So stay tuned for additional guidance around that. If you'd like to get your photo on your card this year before October 25th, that very well may be in the cards for you. No pun intended, that was real bad. Let's see. Also effective October 25th of this year, we will be providing notice within 1 business day anytime we identify sales to non-patients happening. And then essentially the remainder of LD 832 is going to require major substantive rulemaking. Let's see. And then within LD 1880, the provisions that allow licensed cannabis stores to conduct deliveries to hotels and other private businesses will become effective, or will not require additional rulemaking in order for us to be able to implement that on October 25th. However, again, keep an eye out because we will have a form that licensees will be able to use to get authorization from these private businesses. Similarly, the change in the allowable package size from 100 milligrams to 200 milligrams will become effective October 25th of this year, as well as the increase from 5 grams to 10 grams of concentrate. So if you didn't hear any provision you were listening for mentioned, that's probably because it's included in our major substantive rulemaking.
One of our attendees asked about who's responsible for getting the permit for an event. I assume the reference is to off-premise sales. I just wanted to note that this is a multi-step process that will ultimately be spelled out in rules, but the law that passed LD 202 does lay out many of the provisions that depend on whether the event is a private event, whether it is a public event, whether it is held at, say, a fair, versus getting permission from an individual property owner. It also requires local authorization. It also requires, under the law that was passed by the legislature, ultimate OCP authorization. It is a multi-step process, as we noted, that will be spelled out in the adult use rules in September. But if not, you can go to the Maine legislature website, and right in the center of the screen, there's a spot for you to type in the LD number, and that's again LD 202. And you can read through, at least in advance of the rules, the bill that the legislature passed as well. And then the last question from Barry: is there a plan for medical testing? Medical testing did not come up in a substantive way by the legislature this session. If it is an issue that is important to you, like any other issue, we would recommend that you make those views known to the legislature in particular. You can make those views known to OCP as well, but definitely something that did not come up in this legislative session in the form of a bill. But if you're interested in that becoming law in the future, making your voices heard in Augusta is obviously an important part of that process. It looks like those are all of our questions. So I want to thank first Gabby for providing a great overview of the legislative changes from the first regular and special sessions of the 131st, and thank all of you for participating. For those of you who want to go back and hear some portions of this that you might have missed if you had to step away or otherwise, this will live on the YouTube channel, OCP's YouTube channel. And if you have employees or friends or colleagues or others in the industry or outside of the industry who were not able to make this event, please feel free to share that link or to direct them to OCP's YouTube page as well. Just a final reminder to participate in the rulemaking processes for the adult use and medical rules. And thank you very much for your participation today.